and thank you for joining us for the debut of Looking Down the Road, which is a show that examines the intersection of the law and road safety. Looking Down the Road started as a concept in our newsletter, and now we're expanding it to a video format so I could have guests on to delve into more detail of the issues that concern road safety and drunk driving. And what better guest to start this series off than Schenectady District Attorney Robert Carney. Let me give our viewers a little bit of his background. He's a lifelong Schenectady resident, born in Schenectady. He has a BA in political science, cum laude, from Union College. He got his law degree at Albany Law School, and his first job after graduating from law school was with the Schenectady Corporation Council. He then joined the district attorney's office as an ADA and continued to work with them until 1982, where he became a partner with the law firm Higgins, Roberts, Bertyard, and Cognier. And in 1986, in the middle of that time when he was a partner at that law firm, he was assigned to be a special prosecutor for Schenectady County. And then in 1990, he was elected district attorney for Schenectady, which he has served dutifully for 8 terms, and I believe he's serving his 8th term now.
That's right.
So the people are obviously very happy with this. And I guess I'll start, my first question to you was there an event or an experience that inspired you to go into law enforcement? What was the impetus for your interest in that area?
Well, I wouldn't say that's how it happened for me. What I was interested in law school was being a trial attorney. So I knew I wanted to be in a courtroom and try cases. If you had asked me during law school which side I would have gravitated to, prosecution or defense, I probably would have said defense. But after I graduated and went to work for the Corporation Council, and I had a chance to do housing code violations and that sort of thing in court, but it was not trial work per se. It was calendar work and moving cases along and that sort of thing. Although I had the occasion to try a couple of small things. But then a job opened up in the district attorney's office, and I knew that I would get, there'd be no better place for me to go to get trial experience than a prosecutor's office. Mm-hmm. So that's what I did. And what I found when I got there was that I really enjoyed working with law enforcement. I loved working with police. I loved getting involved in the investigative aspect of cases. And so it was the actual experience of doing that prompted me to want to do what I do now and have made a career out of, which is working on the prosecution side, working with law enforcement. Although while I was in private practice, I also defended people, and I think that has made me a much better and hopefully fairer prosecutor because I had the experience for 8 years of also defending people.
And what was the impetus for you leaving the district attorney's office to go into private practice?
Well, that was more money at the time.
More money.
No, I laugh about that, but I think my first job as an assistant DA, I was paid $13,000, and when I left the DA's office, I think I was making just over $20,000. And so it was not a place that a young lawyer would look at and say, this is where I'll make a career. One of the things I'm proudest of as district attorney is that I've been able to professionalize the office of district attorney and working with our county legislature and maximizing all our opportunities to get grants. I've been able to raise the salaries so that young lawyers can look at joining a DA's office and staying there as a career, and I have many that have done just that. So it's different. Our public prosecution system, the way we defend people, that's all different now than it was in the late 70s, early 80s when I was starting.
And in 1986, you were chosen to be a special prosecutor. That must have been a ringing endorsement of your abilities and that you could be fair and impartial in a situation like that. What were your feelings about was it something you wanted to do? Well,
this was just an appointment in a particular case where there was a conflict. It was a burglary trial, but it was an appointment that our county court judge at the time, Judge Harrigan, made of me, knowing that I had tried a number of cases in the DA's office that had a number of felony prosecutions that I had conducted. And so he knew that he could trust the case to me, and I came back and did it. And I did try that particular defendant. He was convicted, and it was an example, even though at that point I was in private practice and I was again doing criminal defense work and other kinds of work that the firm did. Criminal wasn't a huge part of the practice. But it was an opportunity for me to get back in the law enforcement sector that I had missed. And it was a real pleasure for me to do that case and work with, it was mostly state police that had done that investigation that led to exposure, an arrest of a burglary ring.
And in 1990, you throw your hat on the ring.
It was 89, actually.
Oh, 80,
I took
okay.
office in 90, but the election was in 1989.
Okay. At that time, we were ravaged by the crack cocaine epidemic, and not just from the use of the drug that was destroying the community, but the violence that was associated with it. How big a factor was that in your campaign, or what you saw as the problem that you thought you could, help to solve it?
Well, there's no question that drugs were the major theme of that campaign, the major issue in that campaign. Now, we didn't actually have crack cocaine yet, nor did we have the violence all of the violence. We was starting, though. What we did was we did have a problem with a lot of powder cocaine at that time. Within a very short period of time, when I took office, it changed over to crack cocaine. And once we got crack cocaine here, and I remember very vividly when we first saw it, we saw it in the pocket of a young man who was murdered in Vale Cemetery. And he had some crack cocaine in his pocket, packaged in a way we had not yet seen, and which became common, little glassine envelopes with little individual chunks of crack cocaine. But he was murdered for his stash of crack cocaine that he had hidden in another location that the murderers knew. So they were actually friends, acquaintances of him, and he was killed by two people. We were able to solve the crime and convict him. But that started the epidemic of violence that every community in this country experienced when crack cocaine came here. But drugs were an issue in the 1989 campaign, even before crack was here. And there was a feeling that the local law enforcement wasn't keeping up with the problem. The prosecutor's office wasn't doing the job. There were instances of people that made drug deals in Albany County but deliberately carried them out in Schenectady County because they wanted to avoid the tougher penalties and sanctions with the judges.
Wanted to avoid Saul Greenberg.
They avoided Saul Greenberg, and mostly Judge Klein, and Judge Harris, who were very tough on drug cases at the time. So that was an issue.
Okay, and I know you go way back to my mom. You pretty much started your career simultaneously, starting in your career with law enfortement, hers as an advocate for drunk driving. How can you talk about how the criminal justice system has evolved with the issue of drunk driving? Maybe from their attitude, from the sentencing,
Sure.
from the juries that should decide these cases.
There's probably no area of the law that has evolved quite as much as the law pertaining to alcohol and drunk driving, and more so people's attitudes about it. As a young prosecutor, I always took it seriously. One of the trials I did, I was assigned to Niskuna Town Court, and I tried a DWI case. So, I remember taking the position that somebody's charged with a DWI. If they had a prior DWI offense, they should be convicted of a misdemeanor, and that was not necessarily where the defense bar wanted to go with those cases. But it was certainly where your mother thought we should go. And one of the first things that she was able to accomplish through her lobbying efforts was convince the legislature to restrict plea bargaining out of the DWI category.
That was the first time in the nation that had been done, and many other states followed suit with.
I remember how the defense bar howled and said, "This is terrible. This is reducing prosecutorial and judicial discretion." And there were people that would try to say, on a DWI case, plead out of the DWI category, take a reckless driving, which is a misdemeanor, but doesn't have any of the sanctions that the DWI statutes did, and the problem was that could mask a whole series of recidivist offenses. Somebody could get DWI after DWI, and nobody would be doing anything about it. In fact, I looked at some statistics before I came. Before 1981, the average blood alcohol content of those that were arrested for DWI was 0.19. 85% of them were reduced or dismissed.
And now that would be an aggravated charge, wouldn't it?
Oh yeah, it would be a misdemeanor without reduction. The average fine back then was $11. There were in that time period of pre-1981. The statistic I've seen is that there were 1,181 people killed in alcohol-related crashes in New York State alone. In the last year that we have statistics for, in 2016, it was 283. So you can see the dramatic impact in traffic safety that we've had because of these changed attitudes. And after the legislature passed the law restricting plea bargaining, and by the way, that doesn't mean that a prosecutor has to go through with a case that he can't prove. Mm-hmm. If a case just can't be proven, well, the district attorney can obviously dismiss it or take a plea to another traffic offense, as long as you have a valid reason that you are able to state on the record, and you must state it on the record. Mm-hmm. The next significant thing was the formation of the Stop DWI program, which was, I think, in 1981.
Yes.
Which is where all fines for DWI, which were then bumped up, DWI, DWI,
funded the apparatus
go back to the counties,
mm-hmm.
and they fund enforcement actions by going to the law enforcement agency. They fund prosecution positions. They fund probation positions. Mm-hmm. They fund things like victim impact panels and special law enforcement operations if you want to put on extra patrols for significant holidays or St. Patrick's Day or the New Year's Eve, that sort of thing, roadblocks, So because of that money dedicated to that, then there was a plan in every county how best that county felt that they can use those resources to fight the problem.
And looking back on it, once the tougher laws were passed, was there a curve or a challenge as a prosecutor that you had to do to work with juries? You see that there's these new laws that are in place. Did the juries embrace them, or were they skeptical about it, or what? How did that play out?
Well, there was always a concern when I started off in this career that jurors would sympathize with the defendant. They'd say, well, I've been there, I've done that, that could be me. I haven't seen that attitude, and certainly much less over time. I think now there's a recognition that this kind of behavior imperils the lives of me and my family and my loved ones, and I should treat it seriously, just like law enforcement does. So there's definitely been an attitudinal shift amongst people about this problem. And you see that with the laws continue to change to get tougher and tougher upon this, and particularly upon recidivists. Also young drivers. I mean, they're just the simple fact of if you get an alcohol-related traffic offense and you're under 21, your license is going to be revoked for a longer period of time than if you were over 21. The fact that alcohol-related traffic offenses that have caused serious injuries or fatalities are subject to much more severe punishment. Vehicular manslaughter and aggravated vehicular manslaughter are now higher level felonies than they ever were. So there's greater punishment that can be meted out, and we see this in our courts. And I think we see it reflected in the fact that we have fewer traffic fatalities, DWI fatalities, than we ever did. So these are all really positive changes that owe their genesis with the movement that your mother certainly started.
In this area locally, the trending has been that Greene and Columbia County. They have an event called the Safety Tree that my mother started in Schenectady, and Phil Abitabi took that idea and started one at the hospital in Hudson, where every year they pay tribute to victims who lost their lives to a drunk driver. And I believe he said that back in 2015, the trend has been that there are more deaths from prescription drugs or opioids, more deaths due to impairment than intoxication. So have you seen that trend as well here in Schenectady?
Yes. Yeah, I can think of two two incidents in which there were fatalities, including the terrible case in Duanesburg where 3 generations of one family were all killed in a collision with an impaired
then Claudia
driver.
Boone, who was killed on Erie Boulevard. Is that the other case?
Oh, I know that. Then I'd forgotten about that one. That was a pure drug case. Okay. Mm-hmm. The other one I'm thinking about was a young woman named Mara Oakes, who was killed on Route 7. This was a number of years ago, where her husband was in the car and he was seriously injured. Both the feature of the Duanesburg case and the Route 7 case in Niskuna were very low levels of alcohol, just something that was a 0.02 or 01, 02, 03, something that wouldn't rise to the level of impairment to the point, or intoxication, the 0.08 level that we have now in our law, coupled with some sort of a drug use, a prescription drug. I think it might have been Xanax in the Route 7 situation, and I don't remember which one it was in the Duanesburg.
Was that more challenging when you didn't go by this traditional BAC?
It is a little more challenging, but when you look at the medical research and the literature on those types of cases, you'll see that the synergistic effect of particularly even just marijuana and some alcohol is much greater than just the numbers would show alone for the. So if you have a combination of a little bit of marijuana and a little bit of alcohol and some sort of prescription, even it could be, for a mood disorder or a relaxant, something like that, an antidepressant even at times, the synergistic effect of all that makes for very dangerous driving. And so experts are available that can shed light on that. In both of these cases, in all these cases, we were able to get guilty pleas without having to go to trial. So we didn't have to cross the threshold of convincing a jury of that. But we were able to convince the defense that the evidence would be sufficient to show a level of impairment.
Maybe a jury might struggle with this new measures to determine whether the impairment. Also, there's been a huge issue of texting while driving. On the RID board, we brought this up and debated whether this was an area we wanted to get into, and people were really torn about it. I've advocated for it because I thought it would bring in younger people, or it would keep us relevant to the issues of the times, and other board members felt that it would diminish our focus and it would take away from what our brand was. And I came to realize that they were right, because there's 6 agencies solely devoted to this. They're doing it better than we could ever do, and it's just not. I mean, you have a brand, you have a mission, and changing that mission, there comes consequences with that. And so, how have the laws evolved on texting and driving?
Oh, sure they have. I remember the first generation of car phones. Cell phones were to be put in cars, to be used in cars. They were encouraged. We've come a long way since then, and of course there have been horrible examples of inattentive driving that have led to fatal consequences all over the place. I think the public education campaign is very important. The penalties have been increased dramatically for texting while driving. The fines are higher.
What about some of the technology where law enforcement can have an app that will determine whether you were on the phone at the time of the crashes? Has that past the constitutional challenges of whether they can obtain that information?
I'm not aware of where we stand on that. I know that is an issue, and it is something where we've certainly looked at that type of evidence when we've had a fatality. I recall the Saratoga County case of the Northway.
Dennis Drew?
What was his name?
Dennis Drew?
Yeah, that one, where the students from Shenandoah and the one from Shaker, I think.
He had the trifecta. He was drinking cocaine, drugs, and
he was on
texting.
the phone. They knew that he was on the phone, and I think they were able to do that historically by looking at the time of his transmissions. But to go the other way and have an app which they can live monitor drivers to see if somebody's on the phone, I don't know if where we stand on that, and I haven't seen that evidence, or that ability to do that, to intercept that sort of data being used.
Another area of drunken driving that I want to discuss with you is the case of Karen and Timothy Morris was the case that really launched my mother, got her motivated. It was like the perfect storm of having an uninterested criminal justice system and a victim who was not, his license wasn't taken away initially at the time, and the defendant that was convicted was ordered to pay restitution. And there was no, and when he had his parole hearing, there was no discussion of how he would pay restitution. He just got out and went to Florida, and that was the last anyone ever heard of him. Now, so how can you talk about how things have improved in holding drunk drivers accountable through restitution and financial means?
Well, restitution was an afterthought back then. As you say, he wasn't even talked about until he was out on parole, or had the judge ordered restitution.
Yes.
It is now mandatory in every criminal case that a judge consider restitution, and if restitution is, if there is a claim for restitution which is viable, the defendant either admits the amount or can have a hearing to contest the amount of restitution. But the judge must impose as part of a sentence, an order providing for restitution, which then is converted to a judgment, so that in the event that somebody is in prison and then comes out and gets a job, that judgment can be enforced through garnishing of wages and that sort of thing. Now, the government lawyer, our office wouldn't. We don't have the ability to enforce a judgment against somebody, but we have an obligation to see that one is entered and filed. Then it would be up to the individual victim to enforce that judgment as any judgment creditor would.
Is it harder to enforce the restitution in a civic case because you don't have the criminal penalties to use as a stick to get them to pay up in their restitution? Can you talk a little about the difference between the restitution in the criminal case and restitution in the civic case?
Of course, restitution in a criminal case is going to just cover out-of-pocket expenses. It's going to cover things like unreimbursed medical expenses. It's going to cover.
It's not going to cover punitive damages.
No, it's not going to. In a civil case, a plaintiff can look for compensatory damages and punitive damages to make the person whole. So, if it's a judgment of a jury in a civil case that somebody has lost some functionality of their body, they're not the same. They have permanent leg injuries, for instance. The jury can return a judgment which compensates the person for that. We can't do that in the criminal justice system. Now, in a civil case, you have to start a civil lawsuit. You have to sue. You have to move that through the civil system till it gets either resolved by a settlement or goes to a jury trial. In a criminal case, the defendant doesn't have any say about how the progress of the criminal case. He's going to get charged and he's going to be moved through the system by by prosecutors, and ultimately, if he is convicted, if he is found guilty by either through plea or through a conviction, then restitution must be made a part of that case. He has a right to, as I said, have a hearing to contest the amount of restitution. But as long as the judge then makes a decision, we accept the bills that oftentimes or sometimes, unfortunately, in these cases, we may be talking about funeral expenses, headstones, that sort of thing, with a fatality. So that would be the kind of thing we would look for restitution for, and a judgment would be ordered. And if there are any, and sometimes the restitution is just voluntarily paid by somebody who has assets at that time.
Okay, and one of the things that we've been working on at RID is trying to pass .05 legislation. In 1988, Surgeon General Koop came out with a recommendation to lower the BAC to .04, which no one took seriously. They kind of considered him as kind of an eccentric nut. But that always resonated with my mother, and she never got the... I mean, a bill has passed in Utah. It goes into effect in December. And it was something that was really important to my mother, and despite never getting the support on it legislatively or amongst other groups that didn't want to go that route, she stuck to her guns, and I think she'd be very pleased to see that a bill has passed in Utah. And some of the things that they've discovered through their research is that in European countries where they've lowered the BAC to .05, it reduces drunk driving, but it doesn't reduce alcohol consumption, and that's always been a big bailiwick for the restaurant industry, saying that people aren't gonna drink anymore. And what's happened in Utah already is that the crashes and arrests for DUI have gone down because people are adjusting to the law. They're having a designated driver, they're using Uber, or they're doing whatever it takes to avoid being in that predicament.
I think you're right about the fact that there's a lot more options available to people these days, easier to use. Before we just had cab service, for somebody who would imbibe too much and needed a ride home, you have to call a cab. Cabs are kind of spotty in the capital region. It's not like being in New York where you just go out to the corner and hail a cab, and you're using public transportation anyway. But now with Uber and Lyft and some of the apps, there's a lot more ability to avoid this kind of behavior. So I could see that there would be arguments in favor of reducing the BAC levels even further. But I'm sure the Tavern and Restaurant Association is not going to like the idea. But I think to get to .05, you still have to have more than a couple of drinks, most people.
Yeah,
that is the case. And if you are having a couple of drinks with a meal, you're probably not going to be at that level. It's very unlikely that you would be. And I think that's the behavior that most people who do socially drink understand to be acceptable. Anything more beyond that is dangerous.
Well, the National Traffic Safety Board did a study, 7-year study in 2013, that said if you pass this, make it the law of the land, you'll save 800 lives. The academics for engineering, medicine, and science came up with another study just this past year, where the bill that was out there, Bill AB 2302, was amended to match the studies. It was at .06. Now they want to have everything unified so they can speak with clarity about what the results of this would be. It's always been discouraging to me, and I'd like your take on this, that when you have a study that says, we can save 800 lives with this, and it's doing by moderating, the way the system is now. 800 lives. I mean, I guess people, they look at that as a number that they can't really connect with. Maybe they could connect with if somebody were to, an individual that they know killed in a drunk driving crash. But I always think that that these studies that present these stark improvements aren't really taken into account when people do it. They're more concerned about the small mom and pop business than they are about saving lives. So what it really boils down to.
Well, you certainly see corollaries to that when they talk about things like gun control and assault weapons. I mean, that's a different topic altogether. But you see something like what happened in Nevada, and you realize that how many people were killed and wounded with weapons that we in New York State have said we're okay with prohibiting, which is military style assault weapons. And yet the national discussion about this is that you can't do that, because that would infringe on the Second Amendment right of people to own that type of weapon, even though I think we all pretty much agree that people don't have a right to own machine guns or bazookas or anti-tank,
Or drive drunk. There's no Second Amendment for drunk driving.
That's right. So it's a similar sort of thing, isn't it? Where, you say, but we would save lives if we prohibited that type of weapon. Because even if you went on a shooting spree, it would be with a handgun or a rifle, and you would kill fewer people. So it's the same kind of argument, where we could save 800 lives with a lower BAC. Well, how many lives could we save if we just say, let's draw the line at that type of a weapon?
Mm-hmm. Okay. And what your challenges you face as in Schenectady, evolved from different issues. You had the period where there was tremendous gang violence and turf wars over drug trade, and now you're having to deal with prescription drug and opioids. What are the challenges for you, and are you optimistic about how you're going to be able to address them?
Well, opioids are a big challenge, no question about it. We see with the purity of heroin and the existence of fentanyl and carfentanil, these very powerful synthetic drugs. We've seen overdose fatalities, and so we know that harm reduction and public education are very important to fight that, but so too is law enforcement. But we also wrestle with the fact that at the same time we're talking about, look, we have to get tough on those dealers. The attitude about incarcerating people for drug offenses and the movement about mass incarceration has also changed people's thought process about that. And certainly, in the criminal justice system, we believe that people who are drug addicted should be helped to deal with that addiction in a positive way, rather than just incarcerating our way out of the problem. But there is still a role for interdiction. There is still a role for going after the people that bring in mass, particularly the large quantities of heroin and these synthetics into our community. I'm happy that there are law enforcement agencies that are involved in that, and that they are more coordinated with the investigators who look at the sources of those drugs, particularly coming up from New York. And we have people that are now being indicted. The Attorney General has been very active, I know, in indicting people that not only supply drugs locally, but bring them up from the city. And we still have the problem of violence, although it's been very good news on gun violence in Schenectady in the last 2 years. We usually average 5 or 6 homicides a year. During my tenure as DA, that's been the number. Last year, we only had 1 homicide through gun violence. And so far this year, although we've had some shootings, we haven't had any fatalities. So those numbers are good. And I think that speaks to a lot of things, including the economic revitalization of Schenectady, but also smarter law enforcement and trying to work with people who are, we believe, are likely to be in trouble with drugs, that they or with gangs and gun violence, particularly challenging them, going out and talking to them before they have a chance to do that. Just saying, listen, we know you're in this life, and we want you to get out of that life before you do something. If you do something, we're going to come down on you very, very, very tough. But it's not because we don't like you or hope that you don't succeed in life.
So it's a more proactive approach.
Much more proactive and sort of a moral engagement kind of thing. We're doing that with the police are doing that quite a bit. We've had both focused deterrence, we call it, bringing in groups and giving them collective messages, but also individual visits to people that we think are at risk, trying to get them while they're there with their parents or somebody who cares about them, and showing the family that we know what they're involved with, and trying to give them a positive message and a way out. And all of that, I think, has been helpful.
Okay, and my last question is, can Schenectady look forward to having you at the helm as their DA for the foreseeable future?
Well, I'm in the first year of a 4-year term, so God willing, I'll be here for 4 years, and then we'll reevaluate towards the end, because I am getting at the back end of my career, certainly, rather than the front end.
Okay, well, thank you for coming in and
William.
enlightening us to these various issues and the components and how things have changed during your tenure, and I think that our viewers will really appreciate that. So I'm William Aiken. I'm Vice President of Removal Intoxicated Drivers. This has been Looking Down the Road, and this will be an ongoing series that will be taped with various issues, people with expertise in law enforcement and road safety, and we look forward to seeing you next time.